we got a mealy-mouthed justification from Brett Kavanaugh that was like horrifically disappointing.
Brett
Horrifically
Kavanaugh said,
disappointing.
"We should cut the baby in half. That is in the interest of
He
justice."
said, I like beer, not guns.
We are the Armed Attorneys. Today we're talking about a really breaking news story coming out of the Supreme Court of the United States with regard to Second Amendment rights. We're going to be covering the case, what was held at the lower court, what the Supreme Court declined to do, and so much more. But before we begin, show your support for the Second Amendment by hitting that like button. And I'll add a little kind of teaser at this. This may not be the end of the story. We're going to talk about that at the end of the video. But we're talking about, if you want to check this case out, it's Snope v. Brown. It's case number 24203. This is in the Supreme Court of the United States 2025. They just denied certiorari after relisting this thing a bazillion times. And this, I mean, there's a lot of grumbles that this is not good.
They're taking our rights. They're letting them take our rights. So, yes, this is one of the many assault weapons bans cases. And yes, I know there is no such thing as an assault weapon. I know that. But when we're actually challenging the law, what these states' laws call them are assault weapons. So we are just using the statutory terminology. Bear with us. So we have these assault weapons bans, this one specifically out of Maryland. So this has gone up to the Fourth Circuit Court of Appeals. And there are others throughout the country where the lower courts have basically said, sure, AR-15s aren't arms. You don't need those. This doesn't even get to a Bruin analysis. If it did, it'd fail because of, whatever just bullshit reason they're coming up with that day. But you know who should not be swallowing that line of bullcrap is the Supreme Court of the United States, because this is largely the same Supreme Court that gave us New York State Pistol and Rifle Association versus Bruin. And yet, so what happened? Richard, do you want to go through the lower court posture and then we'll go through what they said?
Yeah, so the long and short of it is we focus on Maryland's assault, again, if you're listening, air quotes, rolling eyes, all the good stuff, their assault weapons ban. And I just wanted to point this out. So this is in the Maryland Code Criminal Law. This is section 4302 and 4303. And they banned and they criminalized the sale, possession, or transfer of a semi-automatic centerfire rifle that can accept a detachable magazine and has two of the following features: a folding stock grenade launcher, flare launcher, or flash suppressor. 2, a semi-automatic centerfire rifle that had a fixed magazine with a capacity to accept more than 10 rounds. Or 3, a semi-automatic centerfire rifle that has an overall length of less than 29 inches. So they effectively worked out all the different types of AR variants. These could include AR, AK variants and things like that.
Any modern sporting
rifle, they covered it with this law. So that's what Maryland had. So, obviously, gun owners not happy about it, challenge it. And I don't want to get any of this wrong, so I'm going to read just a little bit because the procedural history for this is just a little bit wild. So, the district court dismissed the complaint, citing the Fourth Circuit's en banc decision in Kolb v. Hogan. That was a 2017 case which upheld the ban. After the Supreme Court decided New York State Rifle and Pistol Association v. Bruin in 2022, the Supreme Court vacated and remanded the case back to the Fourth Circuit. And they said, hey, check out your earlier judgment. You need to reconsider this in light of New York State Rifle and Pistol Association v. Bruin. And on remand, the Fourth Circuit basically came to the same decision in the dismissal in this case, holding that AR-15s are not protected arms under the Second Amendment because they're most useful in military service, not arms, right, as contemplated by the Second Amendment.
Not in the common use.
But that's a pretty complicated procedural history. You see how these courts play games.
Yes. So this is the second time it went up to the Supreme Court. And essentially, we have, so in order to grant the Supreme Court, right, just take a step back for those of you who maybe don't follow the law as closely as some others, the Supreme Court is under zero obligation to take any sort of cases like this, right? Just your sort of run-of-the-mill constitutional violation. I mean, there are some things that they have to consider, right? I think there's some death penalty issues that they would have to consider.
Yeah.
Federal death penalty motions if filed, but generally speaking,
like habeas motions, not like rules of law or anything like that.
Yes, but generally speaking, in this sort of matter, it's totally discretionary. And so once you appeal cases up to the Supreme Court, which there are a ton that go up, and there are even fewer that even get close to being, voted through, but they still have to vote to decide whether or not to hear something. And it takes 4 votes to hear something. And we did not get the 4 votes to hear this. And I will just take a quick sidebar and say I was just listening to a podcast on the Whiskey Rebellion of
Sure.
around like 1789, 1790, and we don't tar and feather enough politicians anymore, as I think this country's problem.
Yeah, there used to be remedies for. Did you hear Justice Sotomayor talking about, what the remedies were if the Second Amendment was repealed?
No.
Oh gosh, don't go down that rabbit hole, guys. But yeah, they're the remedies. The court doesn't want those remedies.
I just, I feel very strongly that we used to be a country that knew what to do with tyrannical government, and we've outgrown that knowledge, and perhaps we should re-find it.
So we had a fantastic petition filed by a lot of great gun groups saying, "Hey, Supreme Court, Fourth Circuit really biffed this one. We need you to review this assault weapons ban." And kind of the big things were, holding these things aren't arms. That's crazy.
Yes.
Applying a limited reading to the Second Amendment, saying it's all about self-defense. Yeah, I mean, that's a key component of the Second Amendment, but that's not the only component of the Second Amendment. That they kind of use this de facto balancing of interests. They did not properly apply the New York State Rifle and Pistol Association v. Bruin standard, which would have held this law presumptively unconstitutional, burdens on the government. Guess what? They didn't do that. And misreading Heller's kind of dangerous and unusual part. You see that in Miller too. So, there's a lot of, this was a target-rich environment for the Supreme Court to come back and clarify some of these issues. And ultimately, certiorari was denied. What did we get on that front?
Yeah, so I'll tell you who doesn't need to be tarred and feathered. And it is Alito, Thomas, and Gorsuch. Those were the 3 who voted to hear this case. This is a very important case, and it is not the only court who has decided that assault weapons are bannable in this country in flagrant violation of the Bruin decision. We got a mealy-mouthed justification from Brett Kavanaugh that was like horrifically disappointing.
Brett Kavanaugh said, "We should cut the baby in half. That is in the interest of justice."
He said, "I like beer, not guns."
That's right.
Is what he said. No, essentially he was like, well, this is a very important issue, but it's something that will have to be settled in a term or 2. But, I just not, let's let this play out a little further. Whereas Justice Thomas really laid the hammer down and was like, excuse me?
Yeah.
Excuse me? What did he say?
I wish his dissent had precedential value.
I know.
Yeah, I mean, he covered, hey, look, you misapplied New York State Rifle and Pistol Association. He said, hey, look, you flipped this burden by de facto using this balancing test. You put the burden on the petitioners here to justify, hey, look, y'all need to prove why this thing is constitutional. I mean, that's completely bizarre. And then they messed up this common use standard, and he pointed that out as well. He said, hey, we need to fix all of these issues, come back and clarify. This is the perfect case to do it. We should do it right now. Not the Brett Kavanaugh middle of the road, which...
Yeah.
Yeah.
And in response to Kavanaugh, essentially, he's like, this isn't what we let lower courts do.
Right.
We don't let them flagrantly disregard Supreme Court precedent and say, we'll come back to it in a term or 2, because they will. That's not how we treat constitutional rights. We don't say, and this is, I mean, just this case alone, right? This is the Fourth Circuit. This is
Kavanaugh said there's error in this too.
Yes. I mean, it just really is. It is shocking that Kavanaugh would not vote to hear this case, because
your rights were violated, but we'll handle it later.
Yes, that's exactly it. And Thomas was like, hell no, that is not how we handle fundamental rights in this country. And it is just shocking to me that Kavanaugh was not on board with him. I mean, I'm not shocked by anything Amy Coney Barrett does anymore, but come on, y'all. But so to calm myself down, to calm down my pregnancy rage a little bit, it is, I guess, not as surprising when you think about the fact that we had Miller, and then 80 years later, we had, was it Heller first? Yes, Heller. And then, immediately after we had McDonald, and then we waited a very long time again, although not as long from Miller to Heller, to get Bruin. So they don't have a long and storied history of taking up Second Amendment violations on the reg. However,
You got Cargill v. Garland.
Right. Well, I mean, now,
Right.
post Bruin, right?
Yeah, we're doing pretty
we're rocking
good.
and rolling. But so it's like, if you really start going back through the history of the Supreme Court, you're like, yeah, okay, the Second Amendment really doesn't get that much attention, but by all rights, it should now. It
Yes.
should. We have a new standard. People are misapplying it intentionally, and it should. So, but that's how I'm calling myself down, is like, maybe your expectations were too high, Taylor. I don't know.
Well, and I'll say, not giving any credit to Justice Brett Kavanaugh.
None.
The only thing in the middle of the road of politics is roadkill, and I don't like the way that he kind of mealy-mouthed his way out of this one. But a little bit of credit, there are a ton of assault weapons bans that are making their way up through the intermediate courts of appeals. We don't have, I imagine we are going to see a lot more action in this front. So I don't think that this is the end of the story.
You're calling for a pause on the tar and feathering of Brett Kavanaugh.
I'm saying that hypothetical scenario is not, we don't do that. We still got the ballot box.
Yeah, no, sure enough.
Yeah. But we don't vote for these lifetime appointees. But, what do you how do we check these people? They get impeached.
Yeah, no, we don't. But there really is. I mean, nothing impeachable.
Did you see the history of how many justices used to get impeached and now we don't do it anymore? Or like how many judges used to get impeached?
No.
It used to be happen all the time.
That's fascinating.
We need to bring that back.
We should bring that back. No, there really is nothing that we can do except have outrage. It's lifetime appointments.
Yeah.
Be outraged, but unfortunately, keep voting for the right presidents.
Yeah. But
although
for the
Kavanaugh
time
came on a good list.
For the time being, Maryland's assault weapons ban lives to infringe another day, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please, as always, question and comment for us below. Until next time, we're the Armed Attorneys.